Call the meeting to order. This is meeting number 32 of the Standing Committee on Justice and Human Rights. Today is Wednesday, June the 17th, 2009. Members, you've got before you the agenda for today, and today we're continuing our review of Bill C-232, an act to amend the Supreme Court Act, Understanding the Official Languages. We'll be hearing from two separate panels of witnesses. And just a reminder, again, to everyone in this room, please either turn off your cell phones or set them to vibrate. Please ensure that any telephone conversations take place outside of this room. And also another reminder that BlackBerries should not be left on the table because they do interfere with our sound system. So thank you for your consideration. So for the first hour, I'm pleased to welcome retired Justice John Major. Thank you for being here. Welcome to our committee. I think you know the process. You've got 10 minutes to present, and then we'll open up the floor for questions from our members. So you've got 10 minutes.
Well, my presentation won't be too profound, as I was only invited to this unexpected party last Friday. However, I understand the nature of the amendment, and it is that an amendment to the Supreme Court Act requiring any new nominee understand French and English without the help of an interpreter. And I would begin by saying that there is no question of the right of the litigant to have his case heard in his language of choice in Canadian courts. Certainly the Section 96 courts, that is, his presentation is his right. The basic concept here has to be properly decided, and the judge has to have a complete understanding of the case. And the ideal, of course, would be a perfectly bilingual judge in both languages, but there are very few of those in the country. Of recent memory was the late Chief Justice Lemaire, who was fluent both in the spoken and written language. It is vital that the case is properly understood, and the system must be fair to all parties. But I am absolutely adamant in my view that the test for the appointment of a judge should be competency. That has to be the priority. Anything else that comes with it is a bonus, but it would be a mistake to substitute anything in place of competency. Particularly in the Supreme Court, cases have to be, as near as humanly possible, be correct, because they have a national impact on the whole of the country. Any inadequacies in the language of an appointee presently are handled by way of translation. And I was unilingual for all intents and purposes, and I was on the court for 14 years and made use of the translation, which I found to be very good. There was no case from Quebec or elsewhere that was argued in French that I did not feel that I had a complete grasp of the facts and the position of the parties. It's interesting that the United Nations operates the same way, except they have multi-translations because of the nature of the establishment. I guess I'm going to sound like a broken record on the subject, but competency is the cloud that sits over the top of this. Sometimes the matter comes up in a different way. As you know, we have in Canada geographic requirements for 6 of the judges on the Supreme Court. That is, they come from different areas of the country. Quebec has constitutional right to 3 judges. And I've heard the question raised. In fact, in Rothstein's appearance, how do the common law judges feel about deciding civil law cases? And the answer is they feel very comfortable, just as the 3 civil law judges from Quebec feel quite comfortable in deciding common law cases from the 9 other provinces. So the question of understanding a case by virtue of the use of translation, I don't think is a serious problem. I think it is a serious problem for the country as a whole if there's anything less than competency being the first requirement for an appointment to that court. Over the years, there have been no complaints from litigants, at least not made to the court during my tenure there. The Canadian Bar Association does not raise this as any issue. And I suppose I'd say, concluding remark, that does anyone suffer by this proposed amendment? And I say that the litigants suffer if the test of the judge is less than competency. Thank you, Mr. Chairman. Those are the few remarks that I have.
Thank you so much. We'll open up the floor to questions. Who will be going first? Monsieur Damour.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Mr. Major.
I'm getting buzzing because of his BlackBerry. It's still going on.
That's not the BlackBerry. I think it's probably the earpieces. Monsieur Damour, you've got 7 minutes.
On peut voir si c'était les earpiece qui était le problème, je suppose.
I think that maybe my was the problem. But anyway, thank you, Mr. Justice Major. Thank you for being with us here this afternoon. I would like to ask you a few questions. In your opinion, is the Supreme Court the final court of appeal?
So I can't appreciate. Oh, you have. I was saying how good translation was.
We'll make sure you've got your earpiece available. We'll just wait a moment until you've got your earpiece in place.
OK. Merci, Monsieur le Président. Merci.
Thank you, Mr. Chairman. So now you will certainly be able to hear the interpreter and you'll understand the concerns that I might have, indeed. In your opinion, is the Supreme Court the final court of appeal for a Canadian citizen?
Interesting question, and not to be too philosophical, Parliament remains the final court of appeal. But in the judicial system, the Supreme Court.
Donc c'est vraiment le dernier endroit.
So it really is the last place. And asking you the question, I expected you would answer as you did, but as we know, there are other courts that are of a lower level than the Supreme Court. There are bilingual judges. So being bilingual reassures a francophone that they can be assured of having their rights respected in the language of their choice, in their own language, so they can express themselves in their language. And clearly the judge before him or her will be in a position to appreciate the importance of their pleadings. But I'm talking about lower levels of courts. Given that you mentioned earlier on that the Supreme Court really is the last place that a citizen can go to claim their rights, clearly in Canada this isn't an issue of life and death at the Supreme Court, but this is the last court that a person can turn to. You cannot go any further than that. So how do you believe that a citizen could feel really entirely comfortable and assured that they will be treated, despite the language that they speak, and that there would be no danger of their message getting through? Because in a lower court, the person can speak the language of their choice, and there is a guarantee that the person hearing their case will be able to speak, or rather understand, their language. So when we get to the last court of appeal in this country, do you not believe that there's a danger? Because, as I'll repeat, people cannot go any further than that. There is no higher court. It's the end of the road. So if ever that person is not well understood because of the interpretation, and you just had the example earlier, you didn't have the interpretation and you weren't able to understand my question, which I respect, but imagine if the interpretation differed from what I was actually saying. How do you think that a citizen or that person's lawyer, that litigant, would feel that their rights have been fully respected?
It's there. And seeing the litigants argue in French, I never had the impression that they did not feel they were being fully understood. There will always, of course, be the 3 Quebec judges, but the environment and the translation is such that it never occurred in my 14 years. The translation is very good. The parties argue in French and seem quite comfortable if a question is asked, and in many cases the lawyer understands English, so he answers. In other cases, it's translated to him.
Imaginez, Monsieur Major,
Imagine, Mr. Major, if we tried to defend our rights and we really wanted to push and try and say absolutely everything that we had to say before the Supreme Court. We're before the bench, and we want to ensure that the judges can really understand what we're saying and well aware of the direction we wish to take. Are you certain that the judges have no problem with this? It can't be an impression that you have. You have to be absolutely certain. Because I just have to speed up, and I'm certain that it's a little more difficult for the interpreters to be able to follow me. And so imagine with a lawyer who has a flamboyant way of speaking, who's carried away by his arguments and is speaking more quickly than me, and the judge might at some point in time have a problem understanding everything that I'm saying. But the interpreter is also going to have trouble following what I'm saying. So imagine if that's the case, if you, as a judge at the Supreme Court, you're able to hear or understand 100% of what I am pleading as my case.
I know what you're saying, but from my experience, if the lawyer was speaking rapidly, you would ask him to slow down. The translation always seemed to be accurate. The lawyers appeared quite comfortable. Now, I can't speak for what may be their hidden thoughts, but I never had the impression that a francophone lawyer did not feel his case was understood.
mais vous comprendrez que de l'autre côté, un juge
You'll understand that a judge who understands my language, for example, would have no difficulty with the speed of my pleading my case.
Many lawyers speak very rapidly and they're asked to repeat. You have to hear, if you're a judge, what's being said. Some lawyers get excited, speak rapidly, and the court will say, you're speaking too quickly. So you have to adjust to who you have in front of you.
Non, je comprends votre point, mais la...
Well, I take your point, but the thing is, clearly, if there's a judge on the bench who understands my maternal language, I'm from New Brunswick, and it's French for me, so if the judge understands my mother tongue, regardless of the speed with which I'm speaking, he'll understand me. But when you end up working with interpretation, there can be distortions and delays, and I think, and I understand that you can ask the lawyer to slow down, but at some point in time, it might be a way for the lawyer to actually defend his case, and he's there to defend his client's rights and ensure that that client, who is a Canadian citizen, will really see justice, being that it is the highest court of the land. So you can ask the person to slow down, but it's also their way of expressing themselves. So do you not think at that point in time that if there are judges that can understand both languages, guarantees that we can give those lawyers the fullest chances of expressing themselves at the speed with which they wish to speak, and if that's their way of defending their citizens' rights, that will go to its fullest extension. And when the decision comes down, whether it's favorable or not, they will have had a full understanding of the pleading of their case, and they will at least be able to say that at least it was in my language, and no one will be able to say that they didn't fully understand what I said.
That I don't agree with. What we're talking about is a trade-off. In the ideal world, all 9 judges would be bilingual. In a practical sense, it's going to be very difficult to find judges from BC and Alberta that have had the same opportunity to be bilingual. So the test is this: will you sacrifice the competency of a judge in order that he has an understanding without the help of an interpreter to hear the case? And in my opinion, to sacrifice competency in order that all the judges, they may not be bilingual in accordance with the amendment, they just understand without an interpreter. I think it's a bad trade-off for the litigant. I would prefer to have a competent judge who needs the help of translation than someone not as competent who does not.
Thank you. We'll move on to Monsieur Menard.
Alors, merci.
Thank you for being with us this afternoon. I will say with friendliness and with all respect that I'm disappointed by your testimony. It's not shared by a majority of lawyers, and I refuse to make a separation between competency and bilingualism. I think that Mr. Godin showed us.
Mr. Menard represents a riding in Quebec, and he represents the party Quebec Bloc Québécois, but he does not represent the majority of lawyers in this country and shouldn't speak on behalf of them.
Thank you, Mr. Sources. I don't believe that's a point of order.
Ce n'est pas un point of order. This is not a point of order, and you will ask a question at your turn. Now
Monsieur
that's my
Menard,
turn.
Monsieur Menard, please continue.
Monsieur le juge.
Mr. Justice, I am saying that I'm disappointed by your point of view, and I hope that it's not shared by a majority of lawyers, because I refuse to think that there is a separation between competency and language skills. Mr. Godin said in his testimony that for the courts that are at the federal level, there was this obligation to be bilingual. So if for federal judges at courts that are lower level courts than the Supreme Court, this obligation exists, I think that we really should believe as parliamentarians that this should exist for the Supreme Court. So the question I'm asking you is, do you not believe, I don't know why you didn't learn to speak French in your life at some point, and I'm not judging that, but do you not think that our duty as parliamentarians is to say that from this point forward, that if Mr. Godin's bill is passed, that all lawyers across the country who have aspirations to the bench, who wish to sit on superior courts and courts like the Supreme Court, whether they're in PEI or Alberta, in Saskatoon or elsewhere, will have to learn to speak French. And perhaps if you had been subject to the same obligation, you would have made some efforts to learn to speak French. So I think that Mr. Godin's bill sends a clear message to the next generation of lawyers that those who wish to have these responsibilities, and I have no doubt that you served the Supreme Court extremely well, but if the message had been clear when you were in law school, perhaps you might have made the effort to learn to speak French at that time. And I think it is our responsibility as parliamentarians to say that this is clearly something that is needed. If you want to be a judge on the Supreme Court, you have to be competent, and in addition to that, there will have to be the mastery of both languages. So I'd like to hear your opinion on that.
With 15 questions, but let me try to answer some of them. First, this amendment would not have the support of the majority of lawyers in Canada. I doubt that it would have the support of the majority of lawyers in Quebec. That's point number one. Point number two, in my own case, I did not aspire to be a judge. I was invited to be a judge when I was in my late 50s. So your premise that you start off wanting to be a judge and as a result you'll learn French is not practical, because I don't believe most lawyers start out wanting to be a judge. You can't be a judge by choice. You have to be selected. You can't write an exam and be a judge. In the lower courts, as you mentioned, they are entitled to have their case heard in the language of their choice. And in virtually all those courts you have, well, take in Alberta, you have 90 judges. And of the 90 judges, there are some who are bilingual, can hear the case in French. So at the lower courts, it's not a problem. There are enough bilingual judges in both languages. I'm sure the same is true in Quebec. You can have your case heard in English. Supreme Court decision says you can do that, French or English. But we come back to this question. If you have the most competent judge possible available, but he needs to use translation, are you prepared to say to the people of Canada, we're not going to give you the best judge, we're going to give you the best judge that can understand your language without translation?
Je vous répète que d'abord, je ne sais pas.
Well, I repeat, and I don't know what you're basing this on, to think that a majority of lawyers would not share this obligation that is presented in the bill, but I'd like you to tell me a bit what makes you say that. But secondly, I repeat with all due respect that I can't follow your logic. It seems ironic to me. There cannot be a separation, a divorce between bilingualism and competence. The competence will be reinforced and completed by bilingualism, and I refuse to accept that we would be limited. I mean, how many bilingual judges are there? 8 of the 9, we are told, apart from Mr. Justice Rothstein, are bilingual now. So there's no, I don't think we have to make the choice between bilingualism and competence. And we've sent the message to people who are in law school now, telling them that there's the competence is required and bilingualism as well.
If you ask the lawyers this question, do you want the most competent judge, or do you want the most competent judge with some knowledge of the other language? It is incorrect to say you have 8 bilingual judges in the Supreme Court at the moment. You have 8 judges that probably meet the requirement of the amendment, that they have some knowledge of the other language. But to me, and I speak from the knowledge of my own spouse and members of the family, being able to converse is not being bilingual. Being bilingual, understanding the other language fully, is quite a chore. And you can have somebody who is got a very acute legal mind, but is not very good at languages. So if, I'm just repeating, if the test is the most competent versus the most competent who is somewhat bilingual, my own opinion, you don't share it, is I want the most competent judge. It's the same as surgery. I want the best doctor. I don't want the linguist.
We'll move on to Mr. Comartin. You've got 7 minutes.
Thank you, Mr. Chair. Thank you, Justice Major, for being here. I don't want this to be offensive, but I've sat.
You're about offending me.
Okay, thank you. That's actually what I'm getting at. I've sat through the last 4 appointments to the Supreme Court. They were a different methodology, but certainly got a real sense of not only the ultimate candidates, but all of the candidates who were eligible. And because that's all confidential, I can't go into any more detail than that. But I can say to you, Justice Major, that in all those cases, there were, in fact, solid candidates who were fluently bilingual, and if I can just add to that, and had conducted trials and hearings, if they were coming from the appeal level, as they would have to do at the Supreme Court level. So I guess what I'm doing at this point is challenging your assertion that those candidates do not exist and this is the final point I will make, not only do not exist now, but in fact are growing in numbers as the years go by, as more and more competent lawyers and judges will be candidates for the Supreme Court.
And I don't think the fact that they're bilingual is going to be held against them. I said at the beginning, it's desirable. In the perfect world, I would agree. If you can get a talented judge who is also conversant with the language, that's the best of both worlds. But what we have to do is come down to the tough decision, the ultimate decision where you have, and it may not happen, but where you have the most competent judge who doesn't meet the requirements of the present amendment versus a judge who is not as competent but who meets those requirements. And if you get to that hypothetical position, then I say, in the interest of justice for the whole country, you should pick the most competent judge. After all, it's a judge you're looking for. And I agree that chances are you'll be able to find both. But I don't think it should be a statutory requirement because it precludes that possibility of not getting the most competent.
It precludes the possibility of the unusual case or rare case, given the number of competent lawyers we have and judges we have at the lower levels as candidates. That's your position.
Well, yes, that's right. It's essentially my position. I want to make it clear that somebody inferred that I might have said because a person's bilingual, therefore he's not competent. I don't know how that could have been misinterpreted. I'm not saying that. Usually, you find people who are bilingual very competent as judges. I have no problem with that. It's an added feature. It's something that elevates them a step higher than another. But we're not talking about those people. We're talking about the tough case where you have to make a choice, if it ever comes to that, between the most competent but inadequate in this requirement and somebody not as competent. And to me, it would be a mistake to sacrifice competency. If you don't have to sacrifice competency, then it's not a question.
Let me flip that the other side, because I think if there was criticism of your position, this is where it would come from, that what I see, I think most of us who are supporting this motion see that the competency issue includes, that is, you get credit for being fluently bilingual.
Mistake. Competency in the law and competency in language, some people may be gifted in both, but a linguist may not be a good lawyer. There's lots of them that are very good lawyers and they can speak two, maybe more languages. It's not an impediment to be a linguist. But come back to the essential question. You're asked the tough question, are we going to pick competence over the ability to understand the other language? And don't cloud the issue by saying, well, we have a lot of both. If you have a lot of both, you don't need the amendment, and you don't come down to the question of what is the main quality for serving on the court, and it's legal competency. It must be legal competency, at least that's my opinion.
So we're clear, equal competency, one candidate fluently bilingual, we pick the fluently bilingual candidate.
Yeah, I think that's fine.
Okay.
I think you have equal competency plus, and the plus goes to the person that's bilingual or understands the sufficient of the amendment to qualify.
How much more time?
You've got 1 minute.
Just, in terms of the point you made earlier in your presentation, we did have a law professor, lawyer here on Monday, who indicated that he in fact felt that on at least one occasion he did not get a full hearing and a full understanding from the bench because of the translation. He lost on a 5-4 vote.
Frequently the ones that lose have that opinion. I'd like the professor to come. I'd like to challenge him on that. I don't believe it. I know a lot of lawyers that are disappointed. They're English, they go before an English judge and they lose, they walk out and they say, didn't understand a word I said. I mean, it's so natural for a lawyer to shift the blame that I'm not impressed by the professor that came with that story. I don't believe it.
Thank you. We'll move on to Mr. Storseth. You've got 7 minutes.
Thank you very much, Justice Major, for coming. I know it can be very weathering to sit before the committee, so if you need a drink of water or anything, please feel free.
The only resource, I guess.
We appreciate your time today, and somebody that has truly the experience that you have within this field is an eminent resource for us. I first want to start out by thanking you for the lifetime of dedication that you have provided to our country, most recently by leading the investigation into the Air India bombing. You've done great work for our country, and I know everybody around this table appreciates that. On to this issue, I have to admit that I'm not a lawyer, but it does bring some compelling thoughts to my mind. I don't understand how we can take somebody like Justice Rothstein or yourself and say that you shouldn't have been appointed, even though you may have been the most competent legal mind, simply because you didn't have the requirement of functionally bilingual. I think it's important that we recognize the word functionally bilingual, and I'll get to that in a second. We've had some litigants here that are, I'd like just to give you a chance to reiterate your position that you feel that the test of competency should be the most important test for a judge, and competency within the law and the legal field, not competency within any language barriers.
Position or anything else.
Good point. Has there, and Mr. Demers brought the point up of somebody speaking in their native tongue, whether it be English or French, speaking rapidly. Has there ever, as an Anglophone Supreme Court justice or a judge in your prior lifetime, has there ever been a case where an English lawyer has presented in front of you that you've asked him to slow down?
Well, it's a very common reaction, particularly the Supreme Court, whether the lawyer is French-speaking or English-speaking. If it's their first appearance, they're generally nervous. And when a person is nervous, they frequently speak a lot faster than they intend to. And it would happen very frequently that you'd ask the lawyer to slow down, and we'd use the excuse if the translators need time to translate or the clerk needs time, try to relax them. Sometimes they hyperventilate. We call an adjournment. Let them get a drink of water. It's a very trying experience, your first trip to the Supreme Court. So French, English, it makes no difference. People will frequently start to speak so rapidly, and there's usually more English provinces cases just by virtue of the number. So it's more frequent that advice is given to an English-speaking lawyer.
And it's your experience that this hasn't hurt their opportunities in front of the court?
That the oral hearing is the last step in the appeal. Before the appeal is heard, you get the written arguments, you get the judgments from the two courts below, you read that material, you read the argument, you know the case pretty well before you go in. In the hour that the lawyer has, he should pick his strongest point and argue it. But the judges don't learn much about the case in the courtroom. They should know about the case before they get in the courtroom. And that's usually the way it is. You do know the case before you get in. Now, cases don't always go the way you think they might, because a lawyer raises a new point or a judge raises a point. There's an argument around it. People change their mind. But 95% of the cases, that does not happen.
Yeah, one of the things that has been brought up is, and it's been said time and time again, that 8 of 9 of the current justices are functionally bilingual. And this is where the opposition kind of contradicts themselves, because then we've heard witnesses come before us that say that these legal proceedings are tremendously technical, and in being anyway functionally bilingual would not be enough or wouldn't replace the ability of a translator who has a PhD in translation, would be far more competent in relaying what they're actually trying to say through their oral argument rather than being functionally bilingual. Would you have any experience of this being the case, where even some Supreme Court justices who are functionally bilingual still rely on the translation?
I think it happens quite frequently, because if you're not that sure of yourself, you get reassurance from listening to the translator. You may get it right, but that's a backup for you. Being functionally bilingual, I take it more being conversational. Legal arguments are not conversational. They're quite different, as you know. So the translation acts as a backup. Functionally bilingual, I don't think would be of a great deal of help. Completely bilingual is a different thing. Completely bilingual in both languages, well, that's a requirement. It would be, certainly would elevate the court if you had competency and bilingual ability both.
I think you make a great point there. I'd also like to make one other point, that we do have other bilingual countries in the world that have final courts of appeal, countries like Belgium, and they all rely on translators and allow for unilingual judges in those.
It relies on translation. War crimes relies on translations. I mean, those are different circumstances. But as I said in the few opening remarks, the United Nations relies on translations. And translators are not a dime a dozen. I mean, a skilled translator is a very skilled person.
And if I could just ask one final question of you, Justice Major, I would, in your 14 years on the Supreme Court, did you have problems with the translation? Did you ever have any doubts with the translation as to whether or not they were giving you an accurate definition of the argument that was before you?
No. And following the case, we always have a conference immediately. And if anything like that had happened, it just would be so apparent.
Thank you very much for your time.
Thank you. We'll go to the next round. Monsieur Lemay, you've got 5 minutes.
Oui. Oh.
Good afternoon, Mr. Justice. I'll talk to you about my personal experience, if I may, because I appeared before the Supreme Court. And I wasn't pleading the case because I was with a colleague who was pleading, and it concerned the Young Offenders Act. But I just want to share with you the feeling that I had, and I'm convinced that everything you said in answer to Mr. Storth's first question was true, how a lawyer feels when they arrive at the Supreme Court, because we don't go there every day. And it is incredibly important. It's an important case. And my feeling was not only that it was important to be heard, but to be understood. And that is where I have some problem with the judges who cannot follow what is being said. In French, for example, when there's an exchange with the Mr. Justice Lemaire, or the other judge that might have been there, you know how it is. You've had years of experience there that I don't deny. So the importance for us is, you see, the appearances are often very different. The perception of our clients is that the judge wasn't understanding what you were saying. So why does he need to have interpretation? And so we had always appeared in courts prior to that where it was possible to have judges who were fluently bilingual. So my question, and you'll understand the importance of this for many groups, to have this feeling of really being heard and understood. So being heard is not the same thing as being understood. So it's that subtle difference that means that for us it is important that Supreme Court judges, being the final court of appeal of this country, be able to understand us in the language that we speak in French at every level of.
I felt completely comfortable relying on the translator. And I'm here to answer questions, not to ask them, but I'd like you to think of a client you might have had, and you'd say to him, now look, we have our choice of judges, A and B. A speaks both languages pretty well, but he's not as good a judge as B. But if you go to B, you're going to have to rely on the translator. Which judge would you take?
Avec respect, Monsieur le Juge,
Well, with all due respect, that's not the way I see the issue. For me, when a judge is appointed to the Supreme Court, and I have a few years of experience, and as do you, I don't challenge that, but when I think of Mr. Justice Lebel or all of the judges that are there now, they are appointed in different ways, and they all have a tremendous level of competency. I don't doubt that they all deserve to be there. I've only been there once. I don't know any of those judges that would be incompetent. That is the primary criterion, certainly, the first test. But with what we're asking is that that person needs to be, the person pleading needs to be understood by the judge hearing them. So I don't ask my client the question in that way. At the lowest level of the court, my client might have a choice about the judge, but at the Supreme Court level, all of the judges are extremely competent, without question. So I just think that this test should be added, that they should be able to understand the French language.
To your opinion, obviously, but I come back to my opinion that competency overrides every other consideration. I mean, all you want's my opinion. I can't do better than that.
je respecte. Merci.
Respect that. Thank you.
I'll give you 5 minutes.
Okay. Thank you, Chair, and thank you, Justice Major, for your appearance here today. We do appreciate you appearing here as a witness. And just a couple of the points that you did make really stood out to me. Firstly, that there's no question of the right of a litigant to be heard in their own official language. But also the point you made about the translation,
Your mic, I can't
sorry.
hear you.
Can you hear me there? The point you made about the translation obviously being probably very good at the Supreme Court of Canada, but also about competency being the overriding goal when we make, as a government, when we make our selections for the Supreme Court. I happen to agree with you that competency must be the overriding goal, and there was some point made that, you know, I guess at some point in a person's life, they would decide, when I grow up, I want to be a Supreme Court of Canada judge, and then they would begin taking lessons in order to make themselves bilingual, no matter where they're from in the country. I don't see that as realistic in any way. I don't think that's how most people's lives or careers unfold. And I wonder if you may want to, if you can comment on that. Maybe, I know there's no typical path to the court, but maybe on why that would be an unrealistic premise.
If you had somebody who had that ambition, you might live in an area where it was impossible to learn the other language. You know, if you're in, I'll pick Prince George off the top of my head. If you're 12 years old, I don't know that you can learn French. I don't know what the situation is in the Saguenay if you want to learn English. But not everybody has an equal opportunity to learn both languages from the time they begin school. I have a personal opinion that the judges' training, where they become mildly familiar with the other language, does not elevate that much beyond conversational. There's very few, in fact, I know a lot of judges that went to study French, judges that went to study English. They get some knowledge of the language, but you take a 55-year-old and try to teach him a new language so that he or she is bilingual. I think that's a very daunting task and an unusual 55-year-old that can learn it.
Justice Major, if I could just get you to take the earpiece and lay it to the side, far away from the mic, that'll work better. Thank you. Please continue, Mr. Moore.
Yes, and I guess that brings me to my second question. Could you comment possibly on new Canadians? Obviously, Canada is a place where we welcome new Canadians. We welcome them into every aspect of Canadian life. And what about someone that perhaps has come from another Commonwealth country where they obviously don't have the same opportunities to learn both of our languages, or someone who maybe English or French is a second language to them, but had no realistic prospect in growing up of learning both of Canada's official languages. And we have to remember that both English and French are official languages in our country. How limiting would this be to someone in that scenario, and what message perhaps would it send to someone from another country who wants to become a Canadian about their ability to participate?
Well, the French language and English language are the official languages, but you have interpreters, and if someone comes from Asia or Eastern Europe and they don't speak English, the trial does not proceed unless there's an interpreter, and the interpreter interprets. That's true through all the courts. It's most important, however, at the trial court, where the evidence is presented and he may want to testify and so on and so forth. When you get to appeal courts, you're generally dealing with some question of law, and an interpreter, frequently the accused person or the parties to the lawsuit, don't bother to show up. The lawyers are there, but not the parties. But there's nobody in a Canadian court that stands trial that is not entitled to an interpreter.
And finally, if I have time, Chair, you mentioned Justice Lemaire as being bilingual. What level of competency in both languages? Because I think there's, for those that are watching or listening, there's what we think of as being bilingual, and that would be the ability to talk to someone in in both official languages. But what level of competency would someone have to have from the pool that we select to go to the Supreme Court of Canada to be appointed? But what level of competency would they have to never avail themselves of the use of translation services?
My wife is bilingual, completely. French is her first language. When I consider her French compared to some of our friends who are sufficient to meet this test, there's a huge difference. I'm sure my friends over here whose native first language is French would find the same thing. Conversational bilingualism is inadequate to hear a court proceeding. I spoke of Lemaire. Lemaire was one of the few judges who was completely bilingual. Someone who's living as Charles Rentier was also able to write competently, fluently in English and French. He could understand the nuances of the language in both languages. He was truly bilingual, and he was competent. And it's not impossible for people to be gifted in languages and competent in law. But all I'm saying is when you take all the straw away and you come down to the one question, is it competency or is it the ability to get along? You just get along without a translator. Then I say the test has to be competency. The marginal benefit of being familiar with the other language so as to, carry on a conversation, be reasonably familiar, unable to write, unable to read fluently in French or English. I don't see that being much above the translation.
Thank you. Before we let you go, I've got a couple of quick questions. In your 14 years of service on the bench of the Supreme Court of Canada, how many complaints did you actually receive about the translation services that were available? And I'm not talking about people who may have been dissatisfied with the result. Were there any specific complaints about the level of translation or the quality of the translation that was available in those proceedings?
The only complaint would sometimes be on the volume, mechanical. The translation's not working. That's not what you're asking. Otherwise, there was never a complaint.
And the second one is, during your experience on the bench, of the judges you would sit with, how many of them do you believe were bilingual to the level that would be required by the bill before us?
I'd say quite a few.
On average, how many?
It's hard to say in numbers, but I would say, you're talking about the Supreme Court?
Of Canada.
I'd say at least half would meet, maybe half, maybe a little more would meet this test.
And the remainder would require translation services and presumably use an earpiece?
There might be two or three that really need, maybe really need translation services. I think sometimes people whose knowledge of French is not that great should use the translation, but vanity being what it is, they may like to give the impression that they understand fully. I'd give them the translator because of later conversations.
Well, thank you so much. Your testimony has certainly been helpful, and we'll take that under advisement as we move forward with this bill. Thank you so much. We'll suspend for 5 minutes. Reconvening the meeting, and we're pleased to welcome a number of further witnesses to assist us in our review of Bill C-232. I welcome Graham Fraser, our Commissioner of Official Languages, and with him are Pascal Giguère and Christine Norina of the Legal Affairs Branch. Welcome to all of you. I think you understand that you've got 10 minutes for a presentation, and then we'll open up the floor to questions from our members. So, Mr. Fraser, you've got 10 minutes.
Thank you very much, Mr. Chairman. Monsieur le Président, Mesdames.
Mr. Chairman, ladies and gentlemen, members, I would like to thank you for giving me the opportunity to speak to you about my position on Bill C-232, which amends a section of the Supreme Court Act on the bilingualism of judges. Over the past 40 years, since the royal assent of the Official Languages Act, language rights have developed and advanced in Canada through lengthy discussions led by three key stakeholders. Initiated by the Parliament of Canada when the Royal Commission on Bilingualism and Biculturalism was formed, this discussion also mobilized the Canadian public and the courts, especially the Supreme Court of Canada. The dialogue surrounding the application of the the Official Languages Act and the Canadian Charter of Rights and Freedoms has led to new case law, building on the relationship between Canada's English-speaking and French-speaking peoples. It is a relationship that has defined our past, that informs our present, and that will continue to shape our future.
Of language as part of personal and collective identity comes from a Supreme Court decision in the Ford case in 1988, and I quote, "Language is not merely a means of interpersonal communication and influence. It's not merely a carrier of content, whether latent or manifest. Language itself is content, a reference for loyalties and animosities, an indicator of social statuses and personal relationships, a marker of situations and topics, as well as of the societal goals and the large-scale, value-laden arenas of interaction that typify every speech community." This view that the Supreme Court expressed so eloquently has influenced my position on the debate that brings us here today. The bijural nature of Canada's legal system is another factor that's influenced me. Canada does not have one legal system, but two. We are one of a small group of countries to enjoy the richness of both common law, which originated in Great Britain, and the Civil Code, which flowed from Roman law to the Napoleonic Code to New France, Lower Canada, and then Quebec. This is a huge asset for our legal tradition and for many of our lawyers who function within both legal traditions, which together cover most of the world. As the American legal scholar John Henry Merriman wrote, "It is difficult to overstate the influence of the civil law tradition on the law of specific nations, the law of international organizations, and international law." This does not mean that all Supreme Court judges should be educated in both common law and the Civil Code, but they should be able to hear arguments from counsel who've been trained in either tradition, in English or in French, without requiring interpretation. As you know, Canadian laws are not translated. They are written in both English and French. The judges in the highest court of the land should therefore be able to understand nuances found within them when there is a difference between the two versions.
If Parliament were to pass this bill, it would send a powerful message to Canada's law schools that mastering both official languages is a prerequisite for full mastery of the law and for qualification for the most important and prestigious positions in the Canadian judiciary. The nature of Canadian linguistic duality means that Canadians have a right to be served by the state in the language of their choice. It is, in effect, a right to be unilingual. The state is officially bilingual, so that the citizen does not have to be, and citizens can live full and prosperous lives in Canada speaking only one official language with no need to learn the other. This puts the burden of bilingualism on the state, and more particularly on those who play national leadership roles. Parliament has recognized the need for every federal court to be able to conduct proceedings in either English or in French. Paradoxically, there is only one exception, the Supreme Court. In my view, this has perpetuated an unfortunate separation.
Chief Justice of the Superior Court of Quebec gave a speech in Toronto in which he warned of what he called legal separatism. And I quote, Quebec has shown the willingness and the ability to contribute to the building of a national scheme of federal law, but the legal community of the rest of Canada has, by and large, closed itself off and away by simply ignoring the Quebec contribution, he said. There now exists an actual separation in legal Canada, but it's been worked upon Quebec from without, not by Quebec from within. He noted that the academic legal work that had been done in Quebec had gone unnoticed in the rest of Canada in the fields of commercial law, criminal law, and administrative law, and went on to compare the absence of citation of Quebec decisions. Now, one of the more impressive things about the Supreme Court has been how much more bilingual it became over the 3 decades since Deschênes spoke. But it only takes one unilingual judge to require that all discussions occur in one language only. La discussion entourant la nomination.
The debate surrounding the appointment of bilingual judges is nothing new. Like my predecessors, I have already expressed my view on the matter at various forums. In May 2008, I appeared before the House of Commons Standing Committee on Official Languages and shared my view on the appointment process for the next Supreme Court of Canada judge. At that time, I pointed out that knowledge of both official languages should be among the desired qualifications for judges of the highest court of the land. In my opinion, such a standard would show all Canadians that the Government of Canada is committed to linguistic duality in a way that is both symbolic and practical. 1 year later, I still hold this belief. In fact, it seems essential to me that an institution as important as the Supreme Court of Canada not only be composed of judges with exceptional legal skills, but also reflect our values and our Canadian identity as a bijural and bilingual country. We all know that the Supreme Court stipulates that there must be regional representation in the court. This important principle is strongly supported by both the public and parliamentarians. However, I find it strange that this principle is used as an argument against recognizing bilingualism as an essential qualification. I also find it hard to accept the argument that requiring Supreme Court judges to be bilingual would compromise the rights of a unilingual individual who might want to access a seat in Canada's highest court. On the one hand, knowledge of a language is a qualification that can be acquired. On the other hand, bilingualism is already a requirement for judges of other courts in the country and for some 72,000 positions in the federal administration, so that Canadians can receive adequate service. I don't think the bar should be set lower for Supreme Court judges.
Important to ensure that they are all served by judges of the highest distinction and greatest ability who can hear and understand a case in either official language. Given the complexity and the extreme importance of the cases heard by this court, judges should be able to hear arguments presented to them without using an interpreter to understand nuanced and complex legal arguments. I recognize the importance of selecting candidates for the judiciary based on each candidate's professional skills and merit. Where the judicial appointment process is concerned, bilingualism is an important criterion and should be a primary factor of candidates' merit and legal excellence. The amendment proposed in Bill C-232 is for bilingualism to be a prerequisite for appointment. I strongly support this amendment. Thank you very much. I'd now like to answer your questions.
Thank you, Mr. Fraser. We'll move on to Monsieur Leblanc, and you've got 7 minutes.
Merci, merci, Monsieur le Président.
Thank you, Mr. Chairman, and thank you, Mr. Fraser, for your comments. I share your opinions entirely. And, in fact, I hadn't seen or found the contradiction as if you are telling Canadians that you have to reach a certain level of bilingualism to be a member of the executive, say a general in the Canadian Army, but you can sit on the Supreme Court without that same requirement being fulfilled. So it's very useful that you pointed this out in such a clear way. My question is quite simple.
Competency in the law, that legal scholarship, that understanding of the role of the judiciary, all of the traditional factors one would associate with judicial competence should be the sole factors in determining a Supreme Court appointment. and that to introduce a linguistic competence or a bilingualism requirement would in fact lower the bar or would risk a less competent or a less qualified individual, would limit a less qualified individual, would give a less qualified individual a chance to be appointed, whereas an allegedly more qualified or competent person who just doesn't have this bilingualism requirement would be blocked. What would be your answer to that? That's the knee-jerk reaction, is that if we're appointing a judge, and the judge from Atlantic Canada who replaced Mr. Justice Bastarache, Justice Cromwell, is a perfect example, in my view, of a bilingual, highly qualified, competent jurist from Nova Scotia. What do you say to that obvious criticism?
My strong belief is that mastery of both official languages is a critical competence. And so that someone who comes forward and says about a candidate, well, he is very competent, he has all of this experience, he has all this, but if he doesn't have the ability to hear a case that's presented before the Supreme Court in the language in which that case is presented, then he is missing a critical competence. He is actually not as competent as a candidate for the Supreme Court who does have that ability. Now, we're now in a position where 9 of the 10 judges are able to hear cases without interpretation. And so, sorry, 8 of the 9. Thank you for the correction. The result of that is that when the judges are in chambers and are having their discussions, even if it's a case about language in Quebec, and we're waiting for a number of decisions about in which the previous cases, the previous judgments were written in French, the presentations that were made before the court that were made in French, the debate that's going to take, that is presumably going on, perhaps even as we speak, about that case, will have to happen in English. Otherwise, one of those judges will not understand. Well, that's a competence that judge does not have. So I think my view is that this is a skill that is a critical competence to do the job.
Thank you, Mr. Chairman. If there's my colleague, Madame Cody, might have a brief question.
Madame Cody, please.
Thank you very much, and I certainly appreciate your coming here today to speak to the committee and take questions, so thank you for preparing your brief as well. I hail from Newfoundland and Labrador. As you know, we've been 60 years in Confederation, 500 years as an entity, and we have not yet had a member of the Supreme Court of Canada. And being we do speak 2 languages in our province. We do have French language schools. But I fear, because we are not what one would consider a truly bilingual province, that perhaps the competency or the excellence in French may not be there. And I would worry, and I have heard a number of my colleagues from Newfoundland and Labrador question whether or not that would be an impediment to having a Newfoundlander and Labradorian sit on the highest court of this land. Could you comment on that at all?
Well, I would say 2 things. One is that I've been very impressed by the commitment that Memorial University has made to providing language training. I've been very impressed by the number of students from Memorial University who have taken advantage of those programs, who have gone to spend a semester or a year at Saint-Pierre-et-Miquelon. I would note that the CEO of Canada Post, Moya Green, is from Newfoundland, spent time at Saint-Pierre-et-Miquelon herself. My own view is that the nature of the country is that it is quite possible for people to spend their career in their province entirely satisfactorily in the dominant language without the need to learn another. But when they decide they want to play on the national stage, it's at that point that the mastery of both official languages becomes critical. And I've been struck by the fact that in some ways the extremes of the country grasp that reality. There is a degree of commitment to immersion education, to providing opportunities for students at Memorial. There is similarly a commitment in British Columbia. There are 30,000 kids in British Columbia who are in immersion. They're lining up to get their kids into immersion. They have to allocate those places by lottery because people in British Columbia understand that if they want to stay in British Columbia, it's not actually critical for although it would be a lot easier to deliver the Olympics in both languages if there were more people who spoke both languages, but they understand that to play on the national stage, this is a critical competence.
Do I still have time?
You've got half a minute, so really quick question, quick answer.
I'll pass
Is that okay? Thank you. We'll move on to Monsieur Menard. 7 minutes.
Thank you, Mr. Chairman. It's always a pleasure to welcome the Commissioner, and I'm extremely happy, if not euphoric, to hear your testimony, because I said with all due respect that I was disappointed in the previous testimony. I think that our colleague Mr. Godin's bill is essential if we want to send a clear message, and the merit that it will have would be to prepare the next generation of lawyers, and saying that the rules of the game are this if you hope to sit on the bench. So obviously we have a legal system where there's not a lottery to get to the Supreme Court, and there may be a little bit of partisanship at times, but we want the Supreme Court to have only very capable judges. And one of the factors of appreciation, indeed, would be that they are bilingual. That's very important. I was a little bit surprised when a colleague earlier asked a question, and I won't mention any names, but the question could really be seen to be in your area of competency. So it was asked if there were ever any complaints tabled concerning the use of French before the Supreme Court. And the person who appeared before, with all respect for them, treated that very lightly. So you, as a commissioner, are you in the position of telling us, of giving us information on this? Had you ever heard any complaints from members of the legal community on this subject? And I recognize it's a delicate subject, but did you ever receive complaints in this area? Well, I would say two things about that. First of all, with all due respect, I don't believe that a unilingual person is in the best position of assessing the quality of the interpretation. When I see a movie in French with subtitles that are made in English, I'm in a position of saying, I wouldn't have translated that in that way. And when I see a film in German with subtitles, well, I'm not in a position to judge as to whether or not the subtitling was good or bad. So I know that one of your witnesses this week remarked that he had some difficulty, some problems with the interpretation of his own pleading of his case before the Supreme Court. This person made similar comments a year ago when we appeared before the committee. So I was wondering if really it was fair as an observation, but afterwards, and I am very impressed by the work of the interpreters quite often. It's a very difficult job, and I greatly admire the work that they do. I know many interpreters, and I feel that they do a wonderful job. But I personally have had the experience of having my comments before a committee with watching it on CPAC where I said, that's not quite what I said. So when you're talking about nuances, and it's often very easy to interpret and maybe to be a little bit on the edges of the real meaning, and this could happen to a lawyer before the Supreme Court. We never received complaints on the interpretation, but we did receive 2 complaints concerning the inability of certain federal courts because they'd had not enough bilingual judges to hear the cases. So this is a problem I raised with the Minister of Justice. This is very interesting. Now, on this committee, I was a member of the special committee, and when we questioned Mr. Justice Rothstein, I asked him the question with all of the elegance and courtesy of which I am capable, as you know. He made a commitment to learning to speak French, but I don't think that when you're sitting on the Supreme Court, you really are in the ideal circumstances to learn how to speak French. So that's why I think it's better to work upstream than downstream. So do you share that opinion? I absolutely agree with you. And one of the things that struck me is that at some stages rather downstream, there is a kind of training for judges that are not at the Supreme Court, but at the beginning of their careers. And I never took this course, but what I heard about it is very good things. It's good training. I heard it's essential, and it's an intense course on legal French, if I can call it that. So there are also certain law schools that give specialized training. The University of Western Ontario, they have a special course for lawyers who want to master the technicalities of the legal vocabulary in French. So the earlier it is, the better to learn a second language. Thank you, Mr. Chairman.
Out of respect to Mr. Menard, I waited to the end of his questioning, but I'm not, just to make sure there was no problem with the translation, Mr. Fraser, to Mr. Menard's question as to whether or not there's been complaints about interpretation to the Supreme Court. Is it correct that you said there has been no complaints about the interpretation of the Supreme Court, but there's been complaints at lower levels?
And again, not about interpretation, but it's about certain, to the best of my knowledge, je vais demander à mes collègues, est-ce qu'il y a eu des...
I'll ask my colleagues, have there ever been any complaints?
Effectivement, we do not have on file that I'm aware of complaints about the interpretation. But one of the problems about interpretation,
Mr. Fraser, yeah. And Mr. Storseth, that really wasn't a point of order. It's a point of debate, and you can always follow up with a question later on.
Mr. Chair, I asked for a point of clarification. I wasn't sure of the translation that came through.
A point of clarification is not a point of order. I just want to clarify that. So we'll move on to Mr. Comartin. You've got 7 minutes.
The translation.
We didn't take any of that out of my time, Mr. Chair.
No, we did not.
Thank you, Mr. Fraser, for being here. When Justice Major was here, he repeated a fairly common, I was going to say bias, but that may not be fair, perception that the skills of a lawyer, I'm sorry, of a judicial figure are separate from the skills of a linguist. I think I'm fair in categorizing what he said that way. I think the implication from that, and not so much what he said, but I've heard the argument before, is that the skills of the linguist, being able to speak the other language, other official language, is not of assistance in judging judicial skills in this country. I think that's the essence of that argument. I wonder if you could comment on that.
That's not my view. I think that an understanding of both official languages is particularly in a context in which the last court of appeal that exists, the last place that a citizen or a lawyer can make a final case before the courts, I think it's very important that that lawyer or that citizen be understood in his or her language. This is not about benefiting judges. This is about defining the characteristics that are required for the 9 most important jobs in the Canadian legal system. I think that and again, I have a great deal of respect for Judge Major, but I'm not sure that somebody who doesn't speak the other language knows what he doesn't know. Donald Rumsfeld once talked about the known knowns and the unknown knowns, I don't know how a unilingual person can evaluate how important language knowledge is as a professional competence, because it's by its very nature. If you don't speak another language, then you don't understand what you would understand if you did speak that other language.
Okay. You made a point in your presentation about the discussions that go on. I think just everybody here is a lawyer. Rick's not a lawyer. He wouldn't admit to that if he was, I think. Right. But those of us who are know that once the case has been heard, the judges retire to chamber and have a discussion, usually right away, and then subsequently there's discussions in terms of exchange of views. The point that you made in your brief was that when that occurs, it has to be conducted in one of the official languages unless all 9 of them are capable of speaking both official languages. I think we understood that point. What's the significance in terms of linguistic rights, perhaps cultural rights, to that discussion having to always be conducted, I guess, currently in English, if our understanding is that Justice Rothstein is not yet able to speak French?
Well, some of the cases and some of the judges would have a discourse that they have developed and cases that have been argued in French. And so through a case in which it's been argued through the lower courts in French, the judgments have been written in French, the pleadings before the Supreme Court have been in French, all of the Francophone judges would, in order to ensure that everybody understood, would then all of a sudden have to do their analysis of what they had just heard in English. They wouldn't be able to engage in the kind of back and forth that you or I engaging in and that Mr. Maynard and I engaged in earlier, in which Mr. Maynard and I could have a dialogue in one language and you and I can have a dialogue in another. If it were a requirement that this committee had to function in one language or the other, some people would be at a disadvantage.
Those are all the questions I have.
Thank you, Mr. Kilmartin. We'll move on to Mr. Rathgaber. You've got 7 minutes.
Thank you, Mr. Chair, and thank you, Mr. Fraser, and your legal counsel for your attendance here before the committee and for your presentation. I'm going to start out by indicating that I am troubled by both your evidence and I'm certainly troubled by this bill. So I'm going to probably take my questioning from a slightly different tack than my friends on the other side. And I'm quoting from your brief where you indicate that Parliament has recognized the need for every federal court to be able to conduct proceedings in either English or French. But am I incorrect in assuming that the Supreme Court of Canada does conduct its proceedings in either English or French, and a clear distinction has to be made between conducting its proceedings and mandating that all 9 members of the bench are fluently bilingual in both official languages?
There is a distinction, and you're correct that people are able to make presentations before the Supreme Court, but they know when they do so, they have to make a strategic decision evaluating whether they can afford to use the language in which they will be more fluent, or whether they are going to pay a penalty for that, whether some of the nuance is not going to be understood. That's not the case in the federal courts, where people have the right to be heard and to be understood. And this issue of the right to be not only to be heard and be understood is one in which the Supreme Court itself has evolved its own view of the right to a trial in French. In the Société des Acadiens case, back in the 80s, I think, the court at that point ruled that one had a right to be heard, but one did not have a right to be understood. Subsequent decisions in the Supreme Court have altered that view, and I will defer to Madame Giguère to explain a bit of the evolution of that Supreme Court position in terms of the right to be understood.
Go ahead.
Very briefly, yes, indeed, there was a decision in the Société des Acadiens case. That decision still stands on the interpretation of the law. What has changed since then is the manner of interpretation that the court applies and the importance of language. The court has interpreted the importance of language, and it has expressed a different view in Beaulac, for example, where that language has taken a major part, and it has recognized the importance of that in that context in the criminal case. I think that if that case was to be heard again, the Société des Acadiens case, there is a possibility that with the evolution of jurisprudence today, the court would reach a different result that it did back then.
Thank you. Mr. Fraser, I come from Alberta. I was until recently a practicing lawyer at the Law Society of Alberta. I am concerned, quite frankly, that if this bill were to become law, that you would have not yourself, but the Attorney General would have a difficult time finding a competent jurist from the jurisdiction that I used to practice law in for an appointment to the Supreme Court of Canada. Now, you might know better than I don't know if your office maintains statistics on bilingual judges in Western Canada, but I know there are some. But my suggestion to you is that there are not many, but perhaps you have data to prove me wrong.
I guess I would, Mr. Chairman, through you, I would observe that the Chief Justice is from Alberta and is fully competent in being able to hear cases in both languages. She learned it as an adult because she decided it was a critical competency for her to have a full and complete understanding of the law. There is a bilingual judge in Alberta. There are 39 lawyers who are members of the Association des juristes d'expression française de l'Alberta. My sense is that if this private members bill were to become law, you would be surprised at how many lawyers or judges decided it would be worth their while to learn the other official language.
Okay. I appreciate that you're not a lawyer, Mr. Fraser, but certainly your legal counsel are. But you have a sense of what happens at the Supreme Court of Canada. You realize that it's appellate advocacy, that they don't hear evidence, that their decisions are based on written factums that are filed in advance, that upon the conclusion of a hearing, they deliberate, often for months and months, and so I'm not convinced yet, and that this language barrier or the inability of an esteemed justice like retired Justice Major is at a disadvantage when even if the litigant, and it's not the client, it's not the litigant that's in front of him at the Supreme Court level, it's his counsel. But he has the benefit of the time and the benefit of being able to ponder and reponder and read a factum that has been translated. I'm just not convinced that that a litigant is prejudiced through the translation services. And can you help me, or perhaps one of your legal counsel can help me, as to where the problem is when a justice has the benefit of a written factum and the benefit of time to deliberate and reconsider?
I will defer to my legal, but my strong belief is that because we live in a country with a bijural system and two concurrent legal systems that meet at the Supreme Court, and jurisprudence that is written and developed in both official languages, and laws that are written in both official languages, in which the final arbitrator to the nuance as to which version is going to have precedence, having a judge that only understands half of the jurisprudence, half of the decisions that are written, and half of the left-hand column of the law means that they are not as competent as somebody who can read both columns, both traditions, both sets of jurisprudence. But voulez-vous ajouter un peu sur cette question?
Could you add to that?
Interpretation during the hearings before the court, but it's my understanding that the parties can submit their memorandums in the language of their choice, and so there's no guarantee that the judge will understand the facta that the party has submitted.
But will interpretive services not interpret the factum?
Interpret the oral arguments before the court at the hearing.
But not the factum. It's up to the litigants to translate the factum if they so choose.
It's my understanding that the litigants will submit it in the language of their choice, and then it would be up to the judge to have his services.
Thank you.
But again, what that means is the burden of bilingualism is being put on the lawyer and ultimately the citizen who is paying for that lawyer rather than on the court.
Thank you. If I could just ask for one clarification. You mentioned that Chief Justice McLaughlin was appointed from Alberta. As I recall, she was my evidence prof in law school, and I recall her being appointed from the Court of Appeal of British Columbia.
I stand corrected. I think she also served in the courts of Alberta. She practiced in Alberta. She's from Alberta. But I stand corrected.
All right. We'll move on to Monsieur Lemay. You've got 5 minutes.
Thank you for being here. In your presentation, you're talking about a decision, a 1948 decision, the Ford case. I'm sorry. You do not give us the reference, so could you send us that, please? Because on the footnote, normally you would have that. Yes, I'm sorry about that. Indeed, we'll send you that reference. I'd very much like to have it because obviously it's specifically or exactly what I was saying to Judge Major earlier. So what did this case concern? Do you remember? Well, it was a language case in Quebec, and I think it was about signage. Oh, all right, thank you. I'd very much like to have that reference, because if it's the decision I'm thinking of, it is indeed an issue of the subtlety of language and of signage, things that mean one thing in signs that mean one thing in English and one in French. So I think this would be important that my colleagues have a copy of this and at least a reference. We could probably find the decision for you, indeed. Well, if you can send that to us, thank you. I'd very much like to have it. My experience at the Supreme Court is limited to a single appearance. I was accompanying a colleague who was appearing. Would you say that the Supreme Court that at the Supreme Court, rather, the importance is being understood and not just heard. Oh, absolutely, yes. All right, so when there's an exchange, and I was listening to this earlier, I think I'm bilingual, I'm able to understand, but I was listening in English to what was being said, and with all the respect of our interpreters who do a fantastic job, when the speed picks up, then they have a hard time keeping up. It can take more time, it's more difficult, more complex. So it's the same thing at the Supreme Court. So it's during those kinds of exchanges. Because people who appear at the Supreme Court, there's one judge in charge of the file, and he's asking questions. There may be exchanges between the judges who get involved in the discussion, but generally speaking, one judge is in charge of it. And when that person has that file, there are those exchanges, and that's where the subtlety and the difficulties can exist. When you file a factum, it's in the language of your choice, and if it's not translated, they can't read it. So I'm surprised. Are you certain that the Quebec Bar Association or the Canadian Bar Association have never made any comments asking for there to be a higher level of bilingualism at the Supreme Court, other than in the last report? Well, I'll correct what I said. I know there was a unanimous vote at the National Assembly in that regard at the time when Mr. Justice Bastarache retired. It's possible that there's something else. But when I was talking about complaints, I was using the term very specifically. I was talking about the complaints that we would receive in our office. Yes, but I'm saying that never having appeared as a lawyer at the Supreme Court would I file a complaint saying I was poorly served. I mean, I don't know if anyone here strategically can appreciate that, but a lawyer who's appeared before the Supreme Court will never file such a complaint. It might be the Defense Lawyers Association or the Canadian Bar Association. I'd like to know if any of them have tabled complaints. Well, I think effectively that there is some evidence that those associations did give their opinion very clearly. I think you've heard from some of them, but I'll ask Ms. Giguère to speak about other institutions that I may not be aware of. Well, I think that the Association des juristes d'expression française de l'Ontario expressed their opinion, indeed, at the time of the appointment of the successor to Mr. Justice Bastarache. And it was more an issue of the lack of bilingual judges in general, but also they spoke about the necessity to have bilingual judges at the Supreme Court. The Canadian Bar Association also expressed themselves very clearly in the press on this issue, and they, in fact, drafted a resolution that was made public on that. Well, and if memory serves me well, and I don't know if you can say anything about this or contradict what I'm saying, but when someone is pleading a case before the Supreme Court, there is simultaneous interpretation. But when the judges meet amongst themselves to discuss the case with their researchers, because they all have researchers, they're very competent colleagues. I'm calling them researchers, but in any case, there's no interpretation at that level. To my knowledge, no. No, there is none. Okay.
Go to Monsieur Petit. Say 3 minutes.
Thank you. Good afternoon, Mr. Fraser. We are seeing each other regularly at all the committees these days, so welcome to the Justice Committee. You know that this is an issue that is of great interest to us, but above all, given that it's a private member's bill, and you've seen that the bill is very simple, and it's not because there are few words that it doesn't have great import. So the expression that I use, I took directly out of the bill. It says that understand French and English without the assistance of an interpreter. So the question I asked during the last committee meeting on the same subject is the following. Everyone knows I come from a province where there is a bill on the French language. Everyone knows it, Bill 101, and it concerns all stages of appearances before the courts. My colleague who presented this, who tabled this bill, came from a country where it's institutional. So the bilingualism issue, so you understand the distinction. We want to create this institutional bilingualism through this bill, C-232. I would like to know, given you're here to testify on this, when we talk about without the assistance of an interpreter, I know someone said there are many lawyers around here, and Mr. Dosanjh was Attorney General of his province. He's unilingual, and we won't be able to appear before the Supreme Court, perhaps, or I couldn't either, probably. There are many things at play here, but if you're aware of the Supreme Court, factums are sent. There are all kinds of requests and papers that go back and forth asking for assist to appear before the Supreme Court. So I'm going to send all of that in French, even if my colleague is an Anglophone across the way. Of course, he's going to send it in English. So when you say without the assistance of an interpreter, does that mean that the judge is reading through my file, as Mr. Lemay was saying? Now, let's be honest. He's going to have to work without the assistance of an interpreter. That means he's going to have to read all of the factums in the language in which they were submitted, either in English or in French. He's going to have to look at all of the documents, all of the requests in the language in which they were submitted. And thirdly, he's going to have to understand not only what he's heard, he's going to have to be able to understand what he reads, and he's going to have to write properly also, because that's what we're saying. If you're saying without the use of an interpreter, it's not just someone speaking to you, it's an interpretation of all of the material that we receive. So you're saying, how do you understand without the assistance of an interpreter? For you, does that mean just listening, or does that mean for written work as well? It's important. Don't forget, all of this is very expensive. Well, my understanding of this, at our opinion, it deals with the oral, the simultaneous interpretation. Written work is translation, so interpretation is what you're listening to. What is presented orally, the oral submissions in the court, would be simultaneously interpreted for the judge. So if you look at the three criteria of language competency that are used in the public service, there is the understanding that's written, and there's oral comprehension as well. So the candidates find oral interaction very difficult, but we're not asking that. We're not saying that the judge has to be able to pose his questions in French, but he has to be able to understand the presentation, the oral submissions. So generally speaking, there are many public servants that I've met that say I have no problem reading and I have no problem with the comprehension to listening to someone else, but expressing myself in writing I find much more difficult. So it wouldn't be a requirement that the decisions, for example, of the judges be written in both languages. The judges have the right to write their decisions in the language of their choice. That's what's done now. It's a simple requirement to say that people have to understand the submissions, and that the people can plead their cases in the language of their choice. Thank you.
I want to thank all three of you for your testimony today, and we'll certainly take it under consideration as we move forward with this bill. Thank you. We're adjourned.